Okay, so hello everyone. Welcome to the fourth panel. Our first speaker is Professor Dr. Moritz Bälz, Professor of Japanese Law and its Cultural Foundations at the Faculty of Law of Goethe University, Frankfurt. He received his LLM from Harvard University. His research focuses on Japanese business law from a comparative perspective and on dispute resolution in Japan. Professor Dr. Bälz also serves as co-editor of the Journal of Japanese Law. He co-edited the books Formalization and Flexibilization of Dispute Resolution and Central Banking and Financial Stability in East Asia.
Thank you, Talia, for the kind introduction, and also thank you to our hosts for having us here and giving us such great forum for an innovative exchange. I'm also indebted to Ron because he already led us all along the Silk Road, so this gives me an excuse to focus here on Japan, which is my expertise, even though it's not exactly Israel or Germany as the title of the conference might promise. My talk will be about the Japanese experience in dealing with mass torts, and I will have a special emphasis on compensation for the victims of the 2011 Fukushima disaster. I will try to introduce the unique approach taken by the Japanese legislator for this event and demonstrate why I think it has something to do with overlapping jurisdictions. Most modern societies experience mass torts events, which I here will simply define as tortious events affecting large number of victims. Examples range from environmental disasters, for example, from product liability or drug liability cases, war crimes, in antitrust claims, or investment fraud suits. For the justice system, or if you like to use the terminology of our project in Frankfurt, existing juridical systems of decision-making, mass torts pose specific challenges, and two at least can be quite clearly be distinguished. The first would be that in a so-called scattered damage scenario, absent special instruments of collective redress, victims may simply lack sufficient incentives to bring their small claims before the courts. Here the key policy question is how can rational apathy be overcome? It may be acceptable to have small individual claims go uncompensated, but the substantial aggregate amount calls for enforcing the law and abolishing any competitive advantage derived from illegal behavior. Quite differently, the second challenge arises when we see waves of litigations where numerous people have substantial amounts at stakes. An event like a defective product or a natural disaster may trigger a wave of litigation. Here the sheer number of plaintiffs and claims may clog the courts. Justice delayed may amount to justice denied. Here the principal policy question is how can victims be speedily and efficiently be compensated. My focus and with regard to the Fukushima case lies on the second challenge, but still I think both have to be viewed together because some of the instruments discussed for these scenarios cover both scenarios. Any juridical system of decision-making can respond to these challenges either within the court system or outside. And because normally the mechanisms provided outside the court system does not substitute for a litigation, but basically offers an additional route, we face issues of overlapping jurisdictions. Lawmakers not only have to decide on the allocation of resources between the two avenues, whether to expand the court system or initiate additional avenues for compensation, for example, but also to design the relationship between the in-court and out-of-court instruments. This relationship may be, as Peter this morning said, one of rivalry or of competition. And sorry, rivalry or competition on the one hand side and complementarity or cooperation on the other. And my example might show that, or I hope to show, that it may actually be both, that we may have a competition scenario with at the same time complementary effects. As regards the instruments within the courts, the global discussion on collective redress, on the mechanisms of bundling numerous claims into one lawsuit, is dominated by the US-style class action model. So I believe, to the very limited knowledge I have about the Israeli experience, I think that's true for Israel, but it's also true for Japan and, for example, for Germany. So whether as a model or as a cautionary tale, if it's about collective redress, the element or the main subject in the room is always the class action, US-style class action, and whether or not it should be adopted or adapted. US-style class actions are widely credited for overcoming the aforementioned rational apathy problem by setting strong incentives for the plaintiff's lawyers. At the same time, even though this form probably has been the initial motive, at the same time, class actions, by bundling various claims together or numerous claims together and exercising pressure on the defendant to settle the case, class actions often facilitate speedy and not necessarily efficient, but at least speedy compensation. On the right-hand side, you see one of the mass litigation in Germany, the telecom case, which has still not been settled, even though we adopted a special law for this case, namely the German Act on Model Proceedings in Capital Market Disputes, which is a model proceedings instrument, whereas in the United States, the class action, which has been initiated by some US investors, has long been settled. Class actions, last but not the least, can help securing the equality of arms, and the mere threat of class actions often fosters compliance. Despite these benefits, most European, as well as the Japanese law, have not yet developed their own, or have not yet managed to develop their own class action model. Japan historically is strongly influenced by the German civil procedure law, and this therefore is also interesting to look at how Japanese law deals with these questions from a German perspective. In part, this is due to the fact that the opt-out mechanism used in the US model, which is also key to the US model, is hard to reconcile with the different procedural justice notions, which is as we have them in most European jurisdictions as well as Japan. Arguably even more important, the attorney-driven US model depends on some unique features of the US judicial system, including contingency fees and punitive damages, both considered alien by most scholars and practitioners in Germany, for example. Legislators in the US and in Japan therefore have, as opposed to Israel to my knowledge, so far shied away from radically switching development paths. Instead, they experiment with various other instruments. One would be these model proceedings types acts, like the one I mentioned. Another approach is to grant consumer associations and other groups standing rights. And Japan, starting from next year, will have a new so-called Japanese-style class action system, which actually combines both associations' standing rights plus a model proceeding. The term class action is a little bit misleading because it does not include an opt-out mechanism and also has a very limited scope.
Could you say what the model proceeding is?
Well, the basic, the model proceeding would be characterized by a two-step mechanism. In the first step, some common issues are clarified, and then in the second step, based on the result of the first step, the individual can bring his or her claim. But for example, in the telecom case, where we have this special law, or which gave rise to this special law, they never got to a verdict on the individual cases, even after more than 10 years. Outside the court system, compensation or dispute resolution mechanisms have been repeatedly used in various jurisdictions to deal with special risk or unexpected incidents. They can assume a broad variety of shapes. Some of these mechanisms or decision-making instruments are more or less strongly based on tort rules and mimic court proceedings. Others deliberately cut out questions of fault and liability and strongly rely on lump sum payments and categorizations of cases, or in informal procedures as well. Famous case from the German modern legal history would be the Contergan case. More recently, worldwide, much discussed the 9/11 compensation fund in Japan. There's a special dispute coordination commission for environmental disputes, which has been set up after the infamous Minamata mercury poisoning scandal, and which has been working actually quite successfully in settling environmental disputes. Lastly, the European Union has adopted a mediation directive encouraging mediation in consumer disputes, and in part this seems to be motivated by the fact that the Commission has not been successful so far to effectively install collective redress mechanisms for the Union. I also put insurance here because to get the whole picture, I think this should be included. For example, asbestos litigation, which has been a huge topic in some jurisdictions, is not so much bothering the German courts because some of these risks have been covered by insurance. Japan has experienced its fair share of mass torts incidents. Quite historically very prominent are pollution cases. That's partly owed to the fact that Japan, since the turn from the 19th to the 20th century, has been driving forward its industrialization quite recklessly and caused some problems. The man on the right top, Tanaka Shozo, is well known in Japan as Japan's first environmentalist. He led the victims struggle for compensation and against the Ashio copper mine poisoning. Food poisoning has been another field where we have seen quite a few cases. There were various reasons why one might expect that in Japan the courts are not in the center of these mass tort cases. First of all, as I mentioned, there are only limited instruments of collective redress. There are weak in economic incentives for the bar. And also, Japan is well known for its remarkable low litigation rates in general. Finally, it is at least common knowledge that Japanese tend not to aggressively assert their individual rights. Still, if we look at these cases, courts do play a role in mass torts. It is fair to say that victims often had to show extraordinary endurance in order to get a favorable verdict or reach a settlement which they were satisfied with. But it is quite striking how often litigation is initiated by victims groups as part of a broader political strategy or simply in order to confront the other part morally, including the state. On the right bottom, this is from the Minamata litigation, which has been going on even until today. The case has started in the 60s, and even though the Supreme Court has rendered a much discussed verdict in 2004, holding also the state liable for regulatory failure, the case is still not closed. In the Fukushima case, the unique thing is that the legislator decided to open a third avenue besides direct negotiations with the tortfeasor, namely TEPCO, Tokyo Electric Power Company, on the one hand side, and going to the courts on the other. As you can imagine, the damage caused by the Fukushima incident has dwarfed all the cases Japan had experienced before. The vast majority of the claims which have been brought forward so far are directly filed with TEPCO, which is said to have 3,000 staff just working on compensation claims. The second often chosen avenue is the newly established Dispute Resolution Center, which, based on the Nuclear Liability Act, which is basically the substantive basis for all three channels, has a mechanism where attorneys paid by the state work out a settlement proposal, which then can be accepted or rejected by the victims. And TEPCO has voluntarily or under political pressure committed to, in principle, follow or accept the settlement proposals. This center is accessible free of cost, so unless you choose to be represented by an attorney, then you have to pay the attorney and can claim the cost in part as part of the compensation. The liability under the Nuclear Liability Act is a strict, operator-centered, unlimited liability, which is more or less in harmony with international standards, but unlimited, which is not the international rule. It is a difficult task to assess whether the establishment of this center actually was a good thing for various reasons. One is that the settlements result normally are not published and anyway do not give reasons for the proposal. So it's very hard to compare what comes out in the settlements to what is the result in the court cases. In addition, very few court cases have been decided so far, and even though there's some indication in individual cases that the courts seem to be slightly more generous, it is hard to make up a real, to really give an assessment. What can be said is that the center successfully lures cases away from the courts. It serves, from the legislator's perspective or from the state's perspective, it serves like a bypass for the judicial system, avoiding that the notoriously small Japanese judiciary, they afford only 1/10 of the German judiciary, for example, is overcrowded with these claims. And what also can be quite reliably established is that the center achieves a high settlement rate out of the roughly 16,000 cases, which include even more victims. Roughly 83% have been settled, and so the outcomes at least found the consent of the victims in the end. So what can be learned from the Japanese experience with regard to some fundamental problems of such ad hoc compensation schemes? The Japanese experience rather illustrates them than offering a solution. This is true, first of all, with the questions of equal treatment. Bad things happen to good people all the time. One may always ask, why should some, in this case the victims of the nuclear disaster, be offered a special option? In fact, in Japan, there seem to be some tensions between the victims of the tsunami flood and the earthquake itself, and those who are have been affected by the nuclear disaster, which was triggered by the earthquake and the tsunami, because only the nuclear victims are offered this special settlement proceeding. Second general issue concerns the fact that such schemes necessarily have a more pragmatic character. They need to make some compromises on procedural principles and accuracy in dealing with the individual case. Otherwise, they cannot be substantially quicker than court proceedings. After all, formalities in the courts do have their sense, and the Japanese courts do work quite professionally in principle. Finally, these schemes tend to blur responsibilities. In the Japanese case, the key question will be, is also the Japanese state liable for regulatory failure? Actually, there's quite some evidence for that, but the question has been at least postponed because the center does not decide on this question, and the courts haven't decided yet on it, and might also take some more time to do so. To conclude, I think the center is interesting for our workshop because it has some intriguing features. First, it seems well tailored to the Japanese context. In one of the last presentations or comments, we heard that the law must answer to the exigencies of the situation, and I think this job was quite well done in the Japanese case. Japan has a very small judiciary which could not have coped with these huge number of cases. On the other hand, the traditionally also small attorney population has grown quite rapidly in recent years due to reform of the justice system, and there is some pressure on the market, and actually the bar supported that many attorneys got part-time jobs in the center. It also harmonized well with their strong pro bono tradition. And finally, the acceptance of the center seems to profit from the widespread trust into state-sponsored ADR institutions. Second, it is stressed that these settlement proceedings are rule-based. They are based on tort rules and the nuclear liability law. So it can be said that, leaving aside that the settlement, of course, relies on a mutual agreement, that the rationales of decision-making are similar. Finally, and that might be the most interesting part for our workshop here, there's a complementary relationship of the three avenues. Yes, they do compete, they are supposed to compete. After all, we want to lure some cases away from the court, but at the same time, they also complement each other. The courts are relieved from some of the burden. They can concentrate on the hard cases. They can keep their function to develop the law and are not clogged. It is very important that the victims have a free choice and actually can even simultaneously pursue 2 or 3 of these avenues and are not forced to waive latent claims, for example, if they agree to a settlement in the center. And this, at the same time, and I think that's also an important aspect, exercises pressure on TEPCO, both with regard to their direct negotiations with victims, because they get some guidance what the settlements have as outcomes, and also the TEPCO knows people unsatisfied with what they are directly offered may go to the center and come back with a settlement offer. And finally, there's the court option still open. So again, TEPCO is pressured to abide to its promise to accept the proposals made by the center. From my point of view, it is very difficult to say at this time whether the center overall was a good idea. It's hard to say what would be the alternative, but in any case, the success will rely on how this complementary relationship will work out in the future. Thank you.